which has been repealed and replaced by the earlier act, CrPC. I'm sure most of us know from where this thought of replacing came in the first picture. So the CrPC, originally in its form, it is stated that the intent of the law when during the parliamentary discussions, it was stated that the earlier law has become archaic and it is not suitable with the ongoing technological advancements that have happened, and there has been increase in the crime, and based on that, we will discuss the legislative intent in detail, but before going into that, let us fix some ground rules before starting. So if at all, if anybody would want to walk out due to any emergency or any reason, for whatsoever reason, you need not ask me. You can just walk out, and you can just, without creating any hindrance or disturbance, you can just come back in and just pick it up from where it left off. That is the first thing. Second thing is that if you have any doubt or a question, and if it can wait till the end of the session, then definitely we'll take it up at the end of the session. I'll be allotting a separate 10 to 15 minutes of a slot for answering your questions. However, being said that, if at all the non-understanding is such that you are not able to proceed in any manner further, like for example, a situation may arise that you are not able to understand the concept properly, and it is hindering your understanding subsequently, then you may just raise your hand. We will pause for a minute, and if at all we can solve it in the 1 or 2 minutes or 3 minutes, we will solve it, and then we'll move forward. However, if the doubt is such that it would it would impact the entire class for the entire, if I feel that it's going to cost a lot of productive time of the entire class, then the interest of the larger interest of the class, then we'll take that doubt at the end of the class, and I'll answer accordingly, saying that okay, this is in brief. At the end of the class, we can consult outside in the cabin, and we can discuss in depth, or at the end of the class, if the time permits, we can again discuss. So that is the second rule. Third rule is that whenever I am teaching, if at all there needs any communication amongst you, like you would want to pass on something, and you're trying to reach out to your friends and colleagues or something of that sort, then just try and make sure you do not create a lot of disturbance, because the class is big, and it is productive time for everybody. 5 minutes lost is 5 minutes into 40 into 50 people. Leave alone my time. So just imagine the impact of the productive time over here. So that is there. So, and yeah, now coming back to my introduction, is I'm a practicing lawyer and practicing advocate, and I've been practicing before the Honorable High Court of Telangana, mostly deal in the appellate jurisdiction, but sometimes I do come back in the lower trial courts, but mostly my expertise lies in the constitutional law and the criminal law in the High Court. So we argue criminal appeals, we argue various writ matters, and various judicial officers matters also we have argued. So welcome to the class, folks. I hope it's going to be a joy and fun ride at the same time, good learning experience. So as I'd say, my future lords and lordships, leaderships. So let us start. So now let us understand the CrPC in the earlier form. There were many amendments, and the sections were segregated. They were not branched or grouped in a particular manner, because at the time it was enacted. Originally it was enacted in the year originally it took its form in the 1973, but however it copied lot of it from the pre-independence era with the earlier existing acts back then. So that is the reason because there were many amendments over a course of time, so the sections were segregated, and in the parliamentary discussion it was brought up by the honorable Home Minister, stating that it was not able to keep up with the current ongoing advancement in the technology, and there were of, as we know, white collar crime. Even though there were separate acts were brought in, and even the concept of victim, as you might be aware, in the 2008 amendment in the earlier CrPC was brought in. For example, earlier, I'll just give you an example of why the overhaul was needed rather than an amendment. So for example, till 2008 there was just no concept of victim appealing. For example, let us say a trial has happened, a criminal trial. Before going into the nitty-gritties and the in-depth understanding, just to give you a slight perspective, because the question that arises for larger consideration right now is, why not amendment? Why the overhaul? Why the entire overhaul? Why did we kill the entire animal and we brought in a new animal in the form of the BNSS? Or your other substantial law, BNS instead of the IPC. So the reason is that, to give you an example, as we were discussing, in the year 2000 and till the year 2008, for example, a murder had been committed. A person, however, due to lack of evidence or for whatever reason, due to lack of proper prosecution, the accused walked scot-free. Now, the state government did not decide to pursue it in the appeal in the High Court. But I am the kin of the victim. Kin yani? I am the kith and kin. Like either I am the brother, mother, father, or some way related to the victim, and I have faced, because that person has been lost, I have faced the loss. The law did not recognize me till the year 2007. So that is the reason in the year 2008, the Parliament brought in an amendment and brought in the concept of victim. So now victim can also appeal if the state does not decide to pursue the matter. For whatever reason, the state is very busy, we understand. Okay, one small robbery or one small, an offence that is covered by maybe more than 7 years may not, in the larger scheme of things, the director of prosecution may or may not decide. The public prosecutor may or may not give his opinion to pursue the matter in the form of an appeal. What if it happens so that even in the High Court, your appeal is not considered? The state is not going to go and file SLP on your behalf. Why would the state incur that much of a cost? Because at the first stage, the trial, the state has failed. At the second stage, in the appellate jurisdiction before the High Court, the state has failed. Then why will the state, out of its exchequer, put in its resources, go ahead for you and file an SLP? But you, on the other hand, being a victim, you had every reason to, you had every right. You did not have a right to, again, let me correct myself. You had a reason to, but you did not have a right to make that kind of an appeal before the Honorable Apex Court. Now let us take a slightly different approach and let us widen our understanding and let us think it in these terms. Now, I have suffered a major, because of somebody's negligence, I have lost a limb, some grievous hurt was caused. Now, I am a victim of a grievous hurt. Let us imagine. Now, the Honorable Court tried the offence. He is sentenced for 2 years or 3 years, 4 years, 5 years, jo bhi hai, whatever the maximum punishment was, he has been awarded that punishment. He has been convicted for that. But however, does it solve my problem of losing a limb or a leg? No, right? He has been punished. Okay, justice has been served. But what about in terms of my rehabilitation? How do I come out of the situation? There would need some support. Now, according to me, the punishment that was awarded may or may not have been sufficient. However, it would not put me in a position where I could go back to normalcy in my life. Again, I mean, at least I have a reason to grieve too. You may consider it not, or you may not consider it. But I have a reason to grieve before you as a judiciary. So, then, but before 2007, the law said no, we do not recognize victims. Only the state has the power to go ahead and file appeals. Then what about victim compensation? Then still you are aggrieved by it, right? So now, after subsequent to 2007 amendment, which was brought in 2008 in the earlier CrPC, it said that victim, even if he is not convinced or if he is not satisfied with the compensation that has been allotted, he can still file an appeal. In the same manner, there has been a lot of advancement in the technology, as we were discussing. But whenever statements were recorded, let us imagine 164 statements or 161 statements in the POCSO Act 164. As if you have already covered that act, I am assuming you have not covered, you have not crossed that bridge yet. So there is a provision wherein it says that all the statements of the victim must be recorded in camera. Now you are giving that advantage in the form of a special act to victims of the POCSO. Now what about the victims, the victims? Hasn't the technology advanced in a similar fashion for the other people as well? So wouldn't, again I am putting a rhetorical argument before you guys, wouldn't that amount to a discrimination who are the victims in the normal offences but not the offence in the POCSO? Right? Record my statement as well in the video camera. From the prosecution's version, it is, if the victims becomes hostile at some point of time, it would be easier to cross-examine for the prosecution in the process. So wouldn't the chance of securing a conviction increase by using technological means? I say yes. So now the law understood, the parliament in its wide wisdom understood that बहुत कुछ हो चुका है, lot has happened since 1973, but the laws which have been copy pasted even from the before British era, they said कि no, we are going to address these shortcomings and we are going to bring in a new law. So what did the parliament do? It has regrouped the sections in the earlier CrPC. It has regrouped in such a manner that whatever pertains to a particular topic, they have been regrouped under a single chapter. So there is a reason that there has been some increase in the number of chapters and the number of sections. At the same time, they have incorporated, I am just giving you a brief idea before we have not even gone deeply into the topic yet. I am just setting the stage for us to go forward from here. So that is the first thing. There has been increase in sections and few chapters. At the same time, as I said, electronic modes have been recognized, and as we will be discussing further, there has been, if you guys have been following the news, there has been a substantial difference in seeking custody. Rightly or wrongly, that is for the academicians to discuss and think. We are the students of the law, so we are going to learn what is over there. So many, I mean, the many legal stalwarts have come forward and said that it is going to affect the rights of the bail when you are giving that opportunity. Just for the benefit of the larger audience, I'll just give a brief understanding of what has happened. Now the police custody in the earlier CrPC, in the starting, only it was permitted only in the starting 15 days. But now the benefit to the police, that is the prosecution, it has been extended in such a manner that it can be granted whenever the offences are so that the charge sheet has to be filed in 60 days in the first 40 days, and if the offences are such that the filing of the charge sheet timing is 90 days in the first 60 days, the prosecutions can seek custody though of 15 days but in parts. So now that is a major area of concern. Now, not for us, again, for the people who are the legal luminaries who are going to criticize this, they say that yes, though it is commendable that new law has been brought in, however, the major criticism has been that it is going to affect the personal liberty that is enshrined and guaranteed in Article 21, and it has made getting bail a notch tougher than it was earlier. Already we have been hearing this a lot, that getting bail is going like it's getting difficult day by day. Even in our practice we have seen that the laws regarding the bail, the Supreme Court has come down heavily again and again saying that the bail as a matter of right should be granted. You must have heard that sentence, right? Bail is the rule, jail is the exception. So that was the common parlance, that was the common understanding that has been, it was said way back by Justice Krishnamma Iyer, I think in the 70s or 80s, during the emergency times, during the 70s and 80s. Justice Krishnamma Iyer said, bail is the rule, jail is the exception. But now it has transformed in such a manner that jail is the rule, bail is the exception. I mean, with regarding to the new laws that have been brought in, I am not talking about this, even the PMLA, UAPA. So there is this concept of prima facie. Again, we have not gone into the act yet. I am just giving you a brief understanding. As I said, I am setting the stage for us to dive deeper into the questions that are going to arise subsequently while our discussion. So in PMLA and even in the other acts, there is this concept of prima facie. What is a prima facie? There existed no such concept in the normal criminal justice system where it says that prima facie, if you are satisfied that the person has committed an offence, the bail cannot be granted. There is no such thing as in the earlier CrPC, even in the new BNSS. However, the new acts, the PMLA, the amendments that were brought in, even in the UAPA, there were other acts as well. Organized crime, Makoka, it was famous in Maharashtra. It pertained to organized crime in the Maharashtra. So there it says that prima facie, if the judge is satisfied after giving an opportunity of hearing to the prosecutor, section 45 of the UAP Act, if after giving an opportunity, 43D5 of the UAPA, 45 section 45 of the PMLA, it says that if the judge is prima facie satisfied that there exists material to believe that the person has committed an offence, then the bail may not be granted. So getting a bail, as I said, has become a lot tougher than it was earlier. In the backdrop of that, I am just giving you an understanding of when these new criminal laws came into picture. So in this era of evolving jurisdiction, these laws, they tried to mimic the existing circumstances that are there, where they would want to limit the right of the bail to a certain extent. So now what is going to happen? I'll give you the ground reality, because as a practicing lawyer, I'll tell you what is going to happen now. I have not filed a bail application in the new acts yet, as of yet. However, I'll tell you what is going to happen if I am the person sitting on the chair. All they will have to say, the police have to say, is that we are going to seek the police custody. The process is still in. They had whenever you applied for the bail, to the practicing lawyers out here, whenever you applied for the bail, at least in the first bail application, what did they say? Investigation pending है, आपको bail अभी नहीं दी जा सकती. The bail cannot be granted to the accused because investigation is still pending. So in the first 15 days, the magistrate assumed that the police may file a police custody petition, because there is a limit, right, in the first till the first 15 days that they can file and seek police custody. So to protect that right of the prosecution, generally in the non-cognizable offences, not less than 7 years obviously, then Arnesh Kumar comes into picture, we will discuss that. Let us imagine 10 years, the punishment is 10 years. So in the first 15 years, the bail was generally rejected on the ground that the investigation was pending. Though it was not said out loud, but it was implied that because the police have a power to seek your custody, the accused custody in the first 15 days, the bail cannot be granted. However, after the expiry of the 15 days, does that implied condition exist earlier? No. Investigation could have been pending, but the police, having not sought the police custody in the first 15 days, had lost their right to seek the custody of the police subsequently, and they